In this video, I just want to briefly go over Marbury versus Madison and the nature of judicial review. Now, according to most constitutional law scholars, Marbury versus Madison is probably the most important case in the history of constitutional law here in the United States. So it is a very seminal case, it's a very landmark case. It's a really important case to understand in terms of constitutional law because it does establish very core, very fundamental principles, not only of law, but of just U.S. government in general. So we want to make sure that we do understand Marbury versus Madison in detail, right? But the one caveat here to make about Marbury versus Madison and the nature of judicial review is that on an actual constitutional law fact pattern, right, this is typically not an area that can really be tested in a lot of detail, right? Unless you actually have a fact pattern that is set in the 1700s or something, right? All of this that we're going to talk about is very well established law today. So this isn't something you would usually need to discuss in a lot of detail in an actual constitutional law analysis, but it is good, right, to build our foundation and understanding of constitutional law in the United States. We want to know about Marbury versus Madison, and because it is something that you're going to cover in a lot of detail in any constitutional law course, we want to make sure that we do go over it. But again, as long as you understand these takeaways at the end we're going to talk about, you should be in good shape in terms of an actual analysis on a constitutional law fact pattern, right? Just one brief note I wanted to make before we jump into Marbury versus Madison, but we can go ahead and get into it, right? Let's just break down the facts first of Marbury versus Madison. What's going on here? So important to recognize kind of the starting point of Marbury versus Madison in terms of the historical context here is that we have the 1800 presidential election, right? Then at the time in 1800, right, the incumbent president is the Federalist, John Adams, okay? Then we have the 1800 presidential election, and the Democrat-Republican Thomas Jefferson actually defeats the then president, who is a Federalist loyalist, John Adams, right? So the first thing we got to note here is we have the presidential election and we have a shift in power, right? The Federalist, John Adams, is leaving the office, right, of the White House, and Democrat-Republican Thomas Jefferson is coming in, right? This is akin to nowadays where we have two main parties, right? Democrats and Republicans. In the 1800s, right, we had Federalists and Democrat Republicans as the two kind of competing parties. So we have this power shift like we have when Obama goes out of office, who's a Democrat, and Trump comes in, who's a Republican. Same idea happening here, right? In the 1800s, we have this power shift among the parties, okay? So in the final weeks of Federalist control, right, Congress passes an act, the Organic Act of the District of Columbia, right? This act allows the still president, John Adams, right, he hasn't left office yet, to appoint 42 new justices. So of course, what does President John Adams want to do? It's his final days in office, right? He's a Federalist loyalist. What does he want to do with this act? Well, he wants to appoint as many justices as he can that are going to be loyal to the Federalist Party, right? It's his final days of office. He wants to solidify or at least get some justices appointed who are going to be loyal to the Federalist Party even after he's gone and Thomas Jefferson comes in. So he starts appointing as many justices as he can that are going to be loyal to the Federalist Party. One of these justices is William Marbury, okay? But something interesting happens here, right? Secretary of State, who interestingly enough, right, this is John Adams, the still president. Thomas Jefferson hasn't come in yet. John Adams, the Federalist, is still president of the United States. His Secretary of State is John Marshall, who also happens to be serving as the Chief Justice of the Supreme Court, but acting as Secretary of State, right, John Adams gives John Marshall the signed commission of Marbury and others in the closing hours of his presidency, right? So he's going to commission these 42 new justices. So what does he do? He gets the commission papers and he starts signing them in his final hours to get all of these Federalist justices into office. One of them, of course, being William Marbury. So he signs these papers, he hands them to the then Secretary of State, John Marshall, and then this is all in the final hours of his presidency, and then his presidency ends and Thomas Jefferson comes into the White House to take office. Of course, Thomas Jefferson sees all of these signed commissions, right, from John Adams, and he looks at it and he's like, well, I don't want all of these Federalist judges to be appointed. So he actually orders, right, when Thomas Jefferson comes in, he sees all these remaining signed commissions that haven't been delivered, including Marbury's signed commission, and he orders that these commissions not be delivered, right? So, of course, now what happens? Well, we have William Marbury sitting there, right? He's been told that he's going to be appointed as a justice. He's waiting on his commission papers to come in, his signed commission paper from John Adams, but it never comes, right? He's just waiting around and his commission never gets delivered to him. So he, of course, comes to find out that Thomas Jefferson has ordered that these commissions not be delivered. Of course, he's not happy about this, so he wants to seek some sort of redress, right? He wants a legal remedy because his commission is never delivered to him, right? So pursuant to Section 13 of the Judiciary Act of 1789, Marbury seeks a writ of mandamus directing Thomas Jefferson's Secretary of State, James Madison, to deliver his commission. Okay, so a lot of things to break down here, right? First of all, what's a writ of mandamus, right? A writ of mandamus, for our purposes in this video, right, is typically going to be where a court is ordering a government official or compelling a government official to execute some official duty that that government official has. So right here, Marbury, right, is going to the Supreme Court. He's seeking a writ of mandamus from the Supreme Court, right? So he wants the Supreme Court to issue a writ of mandamus that's going to compel Thomas Jefferson's Secretary of State, James Madison, to deliver his commission paper to him, right? That's appointing him as a judge, right? So he wants to have the Supreme Court issue a writ of mandamus that's going to compel James Madison to deliver his commission that he's waiting on, right? And he can do this pursuant to Section 13 of the Judiciary Act of 1789. The Judiciary Act of 1789 under Section 13 allows for this exact type of thing, right? This was passed by Congress, the Judiciary Act of 1789, and Section 13 says, hey, look, in warranted cases, the Supreme Court can issue writs of mandamus to compel government officials to take action, right? And warranted cases, right? And that's up to the Supreme Court's discretion, right? That's what Section 13 of the Judiciary Act of 1789 is all about. So again, Marbury is relying on Section 13 of the Judiciary Act to go to the Supreme Court and ask them to compel, by issuing a writ of mandamus, compel Thomas Jefferson's Secretary of State, James Madison, to deliver his commission. Okay, so when he goes to the Supreme Court seeking this writ of mandamus, this is how we get Marbury versus Madison, right? This is 1803. So this reaches the Supreme Court, right? And the Supreme Court is faced with a tough decision, right? Because just to give a little bit more historical background here, at the time, right? At the time, the Supreme Court has kind of a public perception of being weak or not living up to the prestige that once was thought of as the Supreme Court. So there's a little bit of pressure for the Supreme Court to establish its power, right? It needs to gain back that public perception. It really is looking to establish power as the Supreme Court of the United States. So there's a problem though here, right? Either way the Supreme Court decides, right? And we have Chief Justice John Marshall writing the opinion, making this decision, right? So Chief Justice John Marshall, if he finds for Marbury, right? If he looks at it and says, yeah, look, this, even though your commission wasn't delivered, right? It was signed, so you probably should be provided some type of redress here. We're going to compel the delivery of your commission, right? He finds for Marbury. He risks a confrontation with Thomas Jefferson in the executive branch, right? Thomas Jefferson is ordering that these not be delivered. As President of the United States, he's ordering that the commissions not be delivered. So if the Supreme Court finds for Marbury, right, he's risking a confrontation with the President of the United States, Thomas Jefferson, not something the Supreme Court wants to do, not something Chief Justice John Marshall wants to do here. On the other hand, if he finds against Marbury, basically saying, hey, look, this is beyond our scope of power of the Supreme Court, he looks weak, right? And this narrative continues to grow that the Supreme Court is weak in power and doesn't have that prestige, right? So he's kind of stuck between a rock and a hard place. Either way he decides. Now, Chief Justice John Marshall does something that most constitutional law scholars describe as genius or brilliant, where he actually finds a way to kind of avoid issuing a decision on the merits. He avoids a confrontation with the presidency, but also establishes power for the Supreme Court, right? And a really, really brilliant move on his part. So if you look at the opinion, right, he starts by talking about the merits of the claim. And he says, hey, look, Marbury has a very strong case on the merits here, right? Even though his commission was never actually delivered to him, the then President John Adams had signed it. And when President John Adams signed that commission paper, at that time, Marbury had a vested property interest. So the fact that it was never delivered to him is probably not really dispositive here. And therefore, Marbury should probably be entitled to some form of relief or redress, right? So they basically say, look, Marbury has a really strong case on the merits, but there's a problem with his claim, right? Then they move into a discussion of jurisdiction. And they say, look, Marbury relied on Section 13 of the Judiciary Act of 1789 to bring this claim to us at the Supreme Court. The problem is Section 13 of the Judiciary Act of 1789 is in conflict with Article 3, Section 2 of the U.S. Constitution. Basically, what John Marshall is saying here is that Section 13 of the Judiciary Act is unconstitutional. Right? Section 13 of the Judiciary Act is trying to expand the power of the Supreme Court or expand the jurisdiction of the Supreme Court beyond the jurisdiction that's established in the U.S. Constitution under Article 3, Section 2. Right? So what is Article 3, Section 2 all about, right? If you have your pocketbook Constitution, like I do, now is a good time to flip to Article 3, Section 2, but we'll also put this below the video in case you don't have a pocketbook Constitution. But if you flip to Article 3, Section 2, you'll remember this probably too if you think back to civil procedure. Article 3, Section 2 basically says there's two types of claims that federal courts are going to have original jurisdiction over, right? Remember, cases that arise under federal law and cases where we have diversity of citizenship. Remember, in civil procedure, we talk about this as subject matter jurisdiction, right? Federal courts have to have subject matter jurisdiction to have the authority to hear and decide a case. And remember, we say there we're looking for either cases that arise under federal law or cases where we might have diversity of citizenship, right? Now here, right, so and by the way, and so Article 3, Section 2 then says, look, if the federal court doesn't have original jurisdiction under one of these two kind of types of jurisdiction, the only way the court can hear the case is through appellate jurisdiction, right? So what Section 13 of the Judiciary Act in effect is doing is providing another way for somebody to have original jurisdiction in the Supreme Court, right? You can go directly, like Marbury's doing here, to the Supreme Court asking or seeking a writ of mandamus, right? So essentially, this is expanding that jurisdiction of the Supreme Court, or at least this is what Chief Justice John Marshall is saying. Look, Section 13 of the Judiciary Act is really expanding our original jurisdiction beyond the limit established in Article 3, Section 2 of the U.S. Constitution. In Article 3, Section 2, we talk about having jurisdiction in cases that arise under federal law or in cases where we have diversity of citizenship. Not anything about writs of mandamus, right, and cases that might be warranted. This is really a broad expansion of our original jurisdiction that wasn't vested to us in Article 3, Section 2 of the U.S. Constitution. So the ultimate holding is, for this reason, even though Marbury, you might have a strong case on the merits here, we can't hear and decide this case because the statute you relied on to bring this case to us, right, is unconstitutional, right? It's in conflict with Article 3, Section 2 of the U.S. Constitution. So kind of a tough result there for Marbury, right? You have a good case, you're probably entitled to some relief, but essentially this is outside of our jurisdiction, right? So that's the breakdown, right? The facts and the holding of Marbury versus Madison. But there's some takeaways here that we can dissect that make this case really important. When we look at, okay, what does this finding, this holding actually mean for the Supreme Court moving forward, right? And our first takeaway, right, the number one thing we have to think about here is what this holding really says is that the U.S. government must be based upon the rule of law, right? So what is the Supreme Court doing here? Section 13 of the Judiciary Act of 1789 actually expands the power of the Supreme Court. This is a beneficial law for the Supreme Court. This gives them another way to hear cases, right? This is an expansion of their jurisdiction, right? So even though Section 13 of the Judiciary Act of 1789 is beneficial to the Supreme Court, they're striking it down anyways. They're adhering to Article 3 even when it costs them to do so. Because they're saying, look, the rule of law is more important, right? Our government, our system of government has to be based upon the rule of law. If we're not going to follow the Constitution, who are we? Right? So they're establishing or solidifying this idea that U.S. government must be based upon the rule of law. And they go with this even when it, in a way, hurts them to do this. Because this act that's passed by Congress is really beneficial to the Supreme Court, right? It gives them more jurisdiction. But they're striking it down, saying, no, we're going to stick to our guns. It's in conflict with Article 3, Section 2 of the U.S. Constitution. We're going to adhere to the rules of law, right? So that's kind of your first major takeaway that this case kind of stands for. Next is the idea that the U.S. Constitution is the supreme law of the land, right? This case, Marbury versus Madison, establishes a clear hierarchy, right? They're saying here that the U.S. Constitution is above all law, right? It's the highest law of the land. Even though you, Congress, are important, right? Congress is the ones who passed this Judiciary Act of 1789, right? Even though Congress is a big deal, you guys are creating federal law. It's important, but it's not at the level of the U.S. Constitution, right? The U.S. Constitution is the supreme law of the land. So if there's conflict, right, if Congress is passing law that conflicts with the U.S. Constitution, we're going to say that the Constitution controls, right? This is one of the first cases that really solidifies that the U.S. Constitution is the ultimate supreme law of the land. Right, and finally, and maybe the most important takeaway of this opinion is the third one here on the board, right? The holding solidifies that the judiciary has the power of judicial review. Right, if you look at Article 3 of the U.S. Constitution, nowhere in there does it say the Supreme Court has the power to review acts passed by Congress to determine whether those acts are consistent with the U.S. Constitution. Right, that's not in there, right? Article 3 vests the power of the judiciary and the Supreme Court and the federal court system, but it doesn't say that the Supreme Court gets to review law to determine whether the law is consistent with the U.S. Constitution, right? That's what Marbury versus Madison is really solidifying, as establishing this power, this very important power in the U.S. Supreme Court, right? They're saying with this holding, the Supreme Court of the United States may review law passed by Congress to determine whether the law is consistent with the U.S. Constitution. Right before this case, maybe it's not 100% clear whether the court can actually do this. Can the court interpret laws passed by Congress to determine whether that law is constitutional or not constitutional? Right? And when you really think about this third takeaway, something that's really interesting and why this is a really bold opinion is, who are the people who wrote Section 13 of the Judiciary Act of 1789? Right? Who are all the people in Congress in 1789? Right? This is the same crew that wrote the U.S. Constitution. Right? They wrote, all these members basically of Congress who passed this act in 1789 are the same people who actually drafted the U.S. Constitution. So when you're saying to this Congress, right, that passed this act, right, you would think that obviously Congress knows whether they're passing a law that's in conflict with the document they wrote 10 years earlier, right? But nonetheless, the court's saying, we don't care, Congress, if you wrote the Constitution yourselves. If you pass a law that's in conflict with that document you wrote, we're going to strike it down. We have the power to do that as the Supreme Court. Really a bold holding when you think about it from Chief Justice John Marshall, right? Again, though, these are the takeaways. And the biggest one and the most important takeaway to come away from Marbury versus Madison with is that the Supreme Court has the power of judicial review, right? The Supreme Court can look at law that has been passed by Congress and determine whether that law is consistent with the U.S. Constitution or not consistent. And if it's not consistent, they can strike that law down as being unconstitutional, right? That's what Marbury versus Madison is all about, right? So even though the Supreme Court is giving up a little bit of power, right? They're saying Section 13 of the Judiciary Act is unconstitutional, right? This act that expands their jurisdiction a little bit, they're giving up this power, that's Section 13 of the Judiciary Act, for a far greater power, right? The power of judicial review, which they know will go into the future forever as a very important power, the power to be able to review law and determine its constitutionality, right? It's going to be more important in the long run than Section 13 of the Judiciary Act, which is giving them a little bit of an expansion in their jurisdiction, right? So, really cool case. That's Marbury versus Madison. Now, again, like I said in the beginning of the video, the interesting thing here about Marbury versus Madison is that on an actual constitutional law fact pattern, on a constitutional law exam, right, you probably don't have to run through this as an actual analysis. Unless you had a fact pattern that was like based in the 1700s or something that's pre-Marbury versus Madison, that might force you to kind of discuss some of these issues. But for the most part, right, what do you need to know from Marbury versus Madison in terms of an actual analysis on a constitutional law fact pattern, right? Only that the Supreme Court has the power of judicial review, right? They're allowed to review cases and determine whether they're allowed to review law and determine whether that law is constitutional or not constitutional, right? You can sum it up very easy, right? Marbury versus Madison gives the court the power of judicial review, right? And for that reason, it's not something that you typically have to go into in a lot of detail in an actual constitutional law analysis, but it is important to know, right? And from here, what happens after Marbury versus Madison, right? There's a lot of case law that kind of takes different nuances to this. It solidifies, it doubles down this holding. After you get through some of these cases that are related to Marbury versus Madison, where the court doubles down on Marbury versus Madison, you get to more questions, right? When you get to Fletcher v. Peck and Martin versus Hunter's lessee, right, Aaron v. Cooper, all the way up to Bush v. Gore, right? You probably read all of these cases in constitutional law when you're studying the nature of judicial review. A lot of those cases deal with questions as to, right, if we're saying in Marbury versus Madison, we are establishing that the Supreme Court can review law passed by Congress and review federal law to determine whether federal law is consistent with the Constitution. What about state action? Can the Supreme Court review state law to determine whether state law is consistent with the U.S. Constitution? And the answer again is yes, of course. We all know this, and today in modern time, the Supreme Court does this all the time. But again, that was what the evolution of the case law is in Fletcher v. Peck, Martin versus Hunter's lessee. It's why you read all of those cases, right? And then after that, it's just state action in general. What about state court decisions? Can the Supreme Court review state court decisions and determine whether court decisions are constitutional or not constitutional? And the answer is yes, the Supreme Court can do this, and they do it all the time, right? So I am summarizing a lot here. Those cases probably have importance in a law school setting, but in terms of actual analysis on a constitutional law fact pattern, that's why we're not going to go into a whole lot more detail of the nature of judicial review, because the conclusion is all there, right? Yes, the court can do this. They can review state action, federal action to determine whether that action is constitutional, right? That's Marbury versus Madison and that whole line of cases from Fletcher v. Peck to Martin versus Hunter's lessee, Aaron and Cohen, and all the way up even to Bush v. Gore is probably the most recent case you would study in a constitutional law class. It all gets to the same idea, right? So for that reason, we're not going to go into a ton of detail. We can put a little bit more information about those cases and that evolution a little bit below this video just to touch on it. But again, the more important part of this analysis, right, is going to come in the second half, right, where we get to standing, timeliness, mootness, ripeness, all of that stuff. The case or controversy requirement is going to be the far richer part of your analysis on a constitutional law fact pattern. So that's where we're really going to start breaking down step by step what to do, and we'll get into that in our next video. But until then, guys, I do wish you all the absolute best, and I'll see you at our next video.